What if the person you hired to have your back never told you the full story? You assume your divorce lawyer is your champion, sharpening arguments, exposing every weakness, pushing for the best deal. But the reality is far less cinematic. Most cases resolve quietly behind the scenes, driven by cost, timing, and practical pressure, not courtroom heroics. Your lawyer's first job is to manage risk and close the file. That means they'll lean into quick settlements, boilerplate forms, and predictable deadlines, because dragging out dramatic trials only racks up bills. And while you think you're getting expert guidance, there are hidden layers of strategy and compromise that never make it into the initial pitch. Before you dive into discovery, mediation, or emotional testimony, there are truths you need to know, realities that could save you tens of thousands, protect your priorities, and give you control over your own case. These aren't shady tricks. They're simply parts of the process most attorneys assume you understand or will discover too late. In the next few minutes, we'll uncover 7 things your divorce lawyer might never tell you, but absolutely should, from why trials are rarer than you think to the hidden fees lurking behind that retainer. Each one can shift your approach, sharpen your negotiations, and put you back in the driver's seat of a system designed to move quickly. If you're staring at divorce papers or already knee-deep in filings, listen closely, because the best outcomes come when you know the game and the rules better than anyone else. Most divorce stories you hear end with a dramatic courtroom showdown on TV. Roaring objections, last-minute evidence dumps, a judge slamming a gavel. In real life, it's nothing like that. Fewer than 5% of cases actually go to trial. Instead, your lawyer's main goal is to settle, and fast. Why? Trials are unpredictable. They stretch out for months or years, and they rack up 6-figure bills in expert fees, court costs, and hourly rates. Every day spent preparing for trial is another day you're writing checks. When your attorney tells you, "We'll fight this in court if necessary," what they really mean is, "We'll use the possibility of trial as leverage to push a settlement your way." They'd much rather negotiate a deal behind closed doors than risk a judge they can't predict. That's why the early focus is on mediation and drafting agreements, not cross-examinations or dramatic witness statements. The less time you spend in front of a jury, the less you spend on billable hours, both for you and for the firm. Understanding this changes everything. Instead of gearing up for a gladiator battle, you should be asking your lawyer about their negotiation strategy. How will they use your strengths to pressure the other side? What's their plan if mediation stalls? Which points are worth pushing to trial, and which are better settled now? If your lawyer dodges these questions, they're likely defaulting to the path of least resistance, settlement at any cost, even if it means sacrificing key priorities. The best defense against a quick but poor settlement is clear communication. Tell your attorney exactly which issues you will and won't compromise on. Demand updates on every mediation session and draft agreement. And remember, you're the client, not a bystander. Trials may be rare, but the leverage they represent in negotiations is enormous, if you know how to use it. Your lawyer should help you wield that leverage, not downplay it. That first settlement offer isn't a take-it-or-leave-it decree. It's bait. Your lawyer knows that opening negotiations with a sky-high demand gives you room to come down. It tests your reaction under pressure. When she drops a proposal that seems wildly in your favor or wildly against you, it's rarely genuine. It's a preview of the negotiation dance. Imagine she asks for 60% custody or 80% of the assets in that first draft. Your instinct is to recoil, to panic accept whatever comes next just to make it stop. But savvy attorneys use those extremes to anchor expectations. Your lawyer throws out a counter-anchor, maybe an even more aggressive number. Then the two sides meet in the middle, which often lands exactly where the firms want it all along. Seeing through this tactic transforms your power. Instead of reacting emotionally, you can pause and analyze. What issues are truly non-negotiable? Which numbers are placeholders designed to shape the compromise zone? When you identify the real range, based on evidence, precedent, and your bottom-line priorities, you can craft a counteroffer that steers the dialogue toward your goals. Ask your lawyer, why start there? What's the real target range? If they shrug, you're in danger of being led by the nose. If they explain the anchoring strategy, you gain clarity and confidence to push back. That means no more accepting the first figure out of fear, no more settling for less than you deserve. And once you've decoded the anchors, you're ready to tackle the next hidden pitfall. The surprise invoices that turn a reasonable retainer into a crushing expense. Hidden fees can turn a seemingly manageable budget into a financial nightmare, and your retainer agreement barely hints at how deep the tab can go. When you handed over that initial retainer check, you probably thought it covered everything: phone calls, court appearances, document drafting. But every brief email, every quick call with opposing counsel, every motion to extend a deadline gets billed, often in 6-minute increments at your lawyer's full hourly rate. Even standard tasks can carry extra charges. Need copies? That's photocopying. Want your file digitized? There's a fee for electronic document management. Want to know where your case stands? You'll get invoice entries for client status update. Bringing in an expert, even just for a consultation, can tack on thousands more for consultant fees. And don't be surprised when a trial preparation fee shows up, even if your case never goes to trial. The real kicker is the unpredictability. You budget for a flat retainer, say $10,000, assuming it will stretch through mediation and most negotiations. But as soon as that retainer depletes, you're suddenly authorizing more funds or facing a pause in legal services. Bills keep coming, and each invoice feels like a surprise ambush. By the time you realize how much you've spent, you're so deep in that you can't afford to walk away, even if you're unhappy with the results. The antidote: demand an itemized fee schedule and clear billing caps before you sign. Ask your lawyer to identify which tasks are included in the retainer and which require additional funds. Insist on monthly budget forecasts for upcoming phases: mediation, temporary orders, discovery. And don't hesitate to review every invoice line for questionable entries. Affirm that box at transparent billing is one you'll regret trusting with your financial future. Because in divorce, the most expensive battles aren't always won in court. They're won by whoever controls the billable hours. Make sure that's you, not your attorney's clock. Your emotions drive you to tell a compelling story about betrayal, hardship, and why you deserve more. Your lawyer will coach you on narrative, but judges don't decide cases based on who tells the saddest tale. They decide on cold, hard evidence, documents, records, and timelines. Think about it. You can describe every painful conversation, every broken promise, every night you spent worried, with passion and conviction. But unless you back it up with emails showing her admission, bank statements proving who paid what, or text logs documenting custody requests, it's just anecdote. Judges remember facts, not feelings. A calendar entry showing you picked up the kids' 52 weekends last year carries more weight than a heartfelt speech about being a devoted parent. That means if you haven't spent the last few weeks compiling pay stubs, tax returns, mortgage statements, and communication logs, you're asking the judge to trust your word over a paper trail. And in a system wired for efficiency, that trust goes to whoever hands over the most organized file. Don't let your narrative outpace your evidence. Insist on a document checklist with your lawyer, everything from health insurance records to cell phone bill itemizations. Set up a share drive where you upload screenshots, receipts, and affidavits as soon as they come in. Label them clearly: June 3rd bank transfer, August 12th custody confirmation text, so your attorney can find what they need in seconds. When you walk into mediation or the judge's chambers, you want a binder that lets the judge flip straight to proof, not a stack of your emotions. Because when the judge closes that binder, they don't remember your speech. They remember the pages they saw. And that means documentation matters more than the most riveting story. Standard boilerplate settlement templates are a lawyer's dream. They save time, reduce drafting costs, and give firms consistency across cases. But that one-size-fits-all approach can leave your unique priorities buried under generic clauses that benefit the law firm more than they benefit you. Imagine signing a settlement that includes the firm's go-to alimony language, spousal support to be determined by statutory formula, with no room for exceptions, caps, or termination triggers. That might handle 80% of the firm's clients just fine, but what about your desire to limit support after a cohabitation event or to tie it to inflation adjustments? Those custom needs get lost in the shuffle because the boilerplate fits most and gets filed quickly. The same goes for asset division. A standard property split clause might read, "Each party shall retain all assets listed on their respective schedules," leaving vague terms like respective schedules to swallow any items not clearly identified. If you failed to list a side business or undervalue a piece of real estate, you've effectively ceded it to your ex without notice. And because the template language passed your lawyer's efficiency test, neither side spots the omission until it's too late. Even custody agreements can carry boilerplate pitfalls, predetermined parenting schedules, default holiday rotations, or vague, joint decision-making language that sound cooperative but offers no mechanism for resolving future disputes. If your situation doesn't mirror the average family, those off-the-shelf terms can create confusion and conflict down the road. The remedy is simple but often overlooked. Insist on customized clauses that reflect your actual needs. Before signing, sit down with your lawyer and review every standard paragraph. Ask, does this cover my situation? What happens if we deviate? What exactly qualifies as joint decision-making in medical or educational matters? If the answer is we'll worry about that later, you're rolling the dice on a generic document. A truly client-focused attorney treats boilerplate as a starting point, not the finished product. They'll ask for your input, draft language that captures your specific concerns, and review every section for clarity and completeness. Because when it comes to divorce, efficiency for the firm should never come at the expense of your future. Reject the cookie-cutter approach before you sign. Your long-term welfare depends on it. Timing in divorce isn't just a calendar. It's a battlefield where missed dates become lost rights. Your lawyer will handle deadlines, but if you assume they've got it covered, you risk waking up to irreversible setbacks. Statute of limitations on asset claims, windows for filing temporary orders, deadlines for submitting discovery. You name it, there's a clock ticking. Miss one, and you lose the legal leverage that comes with it. Take discovery, for example. If she requests documents and you don't respond within the court-ordered time frame, the judge can issue sanctions, anything from fines to excluding your evidence or even granting her request by default. Suddenly, you're arguing child custody without your phone logs or pushing back on his financial disclosures without bank statements. That delay gives her team all the power. Then there are temporary order hearings. Most courts require you to request specific relief by certain filing dates, often within weeks of the initial petition. Ask for custody modifications too late, and the judge simply won't consider them until after the divorce is final. That can lock you into a parenting schedule or support obligation you didn't want, and when final negotiations roll around, those temporary orders become the baseline judges are reluctant to alter. Even routine steps, like serving her with motions or filing your financial affidavit, carry strict deadlines. A single oversight can morph your position from active participant to absent or non-compliant, damaging your credibility and negotiating strength. And when you do finally catch up, you're playing defense, trying to explain why you asked for relief 3 days after the deadline instead of focusing on the substance of your case. The remedy is simple. Treat every deadline as a strategic point, not just an administrative chore. Keep a shared calendar with notice reminders set well in advance. Review the court's scheduling order the day you receive it. Ask your lawyer to walk you through each requirement and the consequences of missing it. If you need extensions, file them early. If you need alternate service, arrange it immediately. Because in divorce, timing isn't merely procedural, it's tactical. And the side that masters the calendar controls the playing field. Don't let your rights expire while you wait for someone else's clock to tick. You're in charge of your case. If you don't steer, you'll drift. Your lawyer may be the expert on procedure, but they aren't living your life, paying your bills, or shouldering the emotional fallout. You are. Too many men hand over the reins and treat divorce like a passive process. My lawyer will handle it. But when you check out, you lose sight of strategy, miss opportunities, and let the legal narrative shape itself around you. Remember, every negotiation point, every clause tweak, every deadline decision is yours to weigh. If you're not clear on your priorities, whether that's preserving retirement, maintaining custody balance, or capping support, you'll end up with a settlement that reflects your lawyer's template more than your true needs. Instead, take ownership, review every draft, question each recommendation, and insist on explanations in plain language. Tell your lawyer what matters most, then ask for options on how to achieve it. When they propose a middle ground, evaluate whether that middle ground aligns with your goals or simply expedites closure. By staying engaged, reviewing evidence, attending strategy calls, and even suggesting alternative approaches, you transform from a passenger into a co-pilot. That shift changes everything. Lawyers respond to clients who push back intelligently. Judges notice parties who speak confidently, and opposing counsel recalibrates when they see you know what you're doing. Ultimately, the best outcomes happen when you marry your lived experience and priorities with legal expertise, rather than leaving your future to autopilot. If you've handed off control, it's time to take it back. Because in divorce, the person who defines the strategy wins, and there's no victory in simply letting someone else call all the shots. Divorce isn't a script you hand off and forget. It's a journey you own from start to finish. Your lawyer has expertise, but only you live the consequences of every clause, every deadline, and every dollar exchanged. By understanding that most cases settle long before trial, spotting negotiating anchors, budgeting for hidden fees, backing your story with documents, demanding custom agreements, mastering timing, and actively steering strategy, you shift from passenger to pilot. Those 7 truths aren't about playing dirty. They're about staying informed and proactive, so the settlement reflects your needs, not someone else's template. If you take nothing else from this, remember, the best outcome in divorce doesn't happen by accident. It happens because you ask the right questions, press for details, and refuse to let the process just happen to you. When you combine your priorities with clear legal action, you don't just close a chapter. You set the foundation for everything that comes next.